Your license is important and losing it may not be an option. As a result, it's very important you do everything you can as soon as you can to give yourself the best chance of prevailing and keeping your ability to drive. Now, that being said, you'll be dealing with the Department of Licensing, the government, and I don't even know where to begin with them except to say, expect the licensing part of the DUI to be difficult, painful, and frustrating. Yes, we do in hearings, we do save licenses, but the government has the real advantage here. And I'll discuss that a little bit more in a moment. The first thing you must do, though, is really important. You must request a Department of Licensing hearing within 7 days of the arrest date. This time requirement might change if there's a blood draw, for example, but this is the rule if you have a breath test, a BAC test, or if you refused the breath or blood test. Because we have this very strict timeline, it's important you react right away, and another good reason to consult immediately with a lawyer. Now, to apply for this hearing, you must either send in the form that law enforcement should have provided you, or you could apply online. Now, I do recommend applying online as the system seems to work quite well. It once upon a time didn't, and it does expedite the process. If you prefer to do it by mail, which is mailing in the application you were given, be sure you mail it by certified mail. Now, if you do nothing, your license will be suspended about 30 days from the date of violation. If you do request a hearing, your license suspension will be stayed, which means put on pause, and you'll be okay to drive until a result comes from the hearing. The hearing will be set about 30 days from the date of the incident. You'll hear back from the Department of Licensing about 2 weeks or so after you have requested the Department of Licensing hearing. All right, let me get something out of the way right away. These hearings are tough. They're hard to win, and the DOL will readily tell you just that. In fact, it's all searchable information. Truth is, the majority of people lose these hearings, which sounds really negative, but it's also true, and we want to get that out of the way and be transparent as much as possible. However, the way I look at it is this. You have no chance if you do not request a hearing, and you have a chance if you do. So really, as with most things in life, it comes down to money. These hearings are not cheap. It'll cost you $375. Now, there are times when requesting a hearing does not make sense, and that sometimes comes down to the facts of your case and your financial situation. If the facts of your case do not look favorable, either at the Department of Licensing hearing or in court, then your attorney may discuss the validity of doing the Department of Licensing hearing. Collectively, you might decide it's not worth it, but this discussion should be had with your lawyer. The second reason you might not want to do the Department of Licensing hearing is if you're seriously considering doing a deferred prosecution. If you do a deferred prosecution, you can save your license from suspension unless you refused a breath or blood test. However, if you gave a breath test, then you can save your license by filing an intent to seek deferred prosecution within 30 days of the date of your arrest. The deferred option will not, however, save a CDL. Finally, the Department of Licensing hearing might not make sense if the $375 is not financially possible. If that's the case, you can file the request for a DUI DOL hearing and file a fee waiver. Of course, you'll need to complete the form, and the Department of Licensing will ultimately decide if you qualify for the fee waiver. Once you've requested the hearing, you will receive a notice for the date of the hearing. The hearing will be set within about 30 days of the date of the arrest. This hearing can be continued, which means changed to a future court date if your attorney believes it's in your best interests. Okay, what is this hearing all about? Well, first, it's not a criminal hearing. It's an administrative or civil hearing. This means there are different rules, and these rules are much more relaxed than in court. Also, the DOL hearing is telephonic. It's on the telephone. and not in person. You can choose to be present by phone, but equally, you do not need to appear at this hearing so long as your attorney does. There are 4 main issues to be decided at this hearing. First, was the original stop of your vehicle or contact with you lawful? Second, was there probable cause to arrest you for DUI? Third, were the implied consent warnings read to you and done so correctly? And finally, was the breath or blood test valid, or was the refusal of the breath or blood test valid? And while there are some procedural issues to be considered too, those 4 issues, that's it. We're limited with what we can argue. The rules are very relaxed. The government does not need to prove very much. And finally, you're asking the government to rule against the government. All right, well, the reality of getting a DUI charge is that there is a possibility, a very real possibility, of a license suspension. And the government makes sure of this likelihood by coming at you twice. The first is administratively. You will in fact lose your license 30 days after your arrest unless you appeal the license suspension and, of course, win. Now, the second way you can lose your license is if you're convicted in court of either a DUI or reckless driving. The restricted license is a license that permits you to drive even though you are suspended. Confusing? Yes, but the good news is that if you do receive a suspension, you do have an option to keep driving and keep being mobile. The available restricted license is called the Ignition Interlock License. The license requires an ignition interlock device, SR22 insurance, and the $100 application fee. Do not forget that this type of license is only eligible for the time of suspension, and once the suspension is over and you're eligible for reinstatement, you must reinstate your license as this restricted license is no longer valid. If you have received a suspension, once the suspension is over, you must then reinstate your driver's license. It does not automatically reinstate itself. Check with the Department of Licensing what they need, but typically they will need on file proof of SR22 insurance and a reinstatement fee. Now, depending on the outcome of your case, they may also need proof of installation of the ignition interlock device. If in doubt, ask your attorney or the Department of Licensing. If you're concerned about the validity of your license, you can check your license status online with the Department of Licensing, and it will tell you in real time if your license is valid or if it isn't. The ignition interlock device is another example of a good idea that is poorly executed. An ignition interlock device is a breathalyzer installed in a vehicle that requires the driver to blow into it before starting the vehicle or driving. If there is alcohol detected and that level is too high, the engine will not start. These devices also require a breath sample while driving. Sounds safe, right? Yeah. Well, the problem is these systems are fickle and sensitive. Once again, knowledge is invaluable. When you have one installed, ask the installer every possible question you can think of. And here are a few tips. Do not drink or eat anything within 20 minutes of driving. And this is most especially important when it comes to things like mouthwash. Do not drink or eat anything in the car. Now, there are too many drinks that might cause problems, such as fruit juices, kombucha, obviously, and even energy drinks. Yep, looking at you, Red Bull. There are some food products that can actually cause you problems too, like breath mints, gum, spicy foods, and food with yeast. Do not let anyone play with the device. This is not a toy and can land you in trouble if there's a violation. Do not warm up the car and leave it running. The ignition interlock device may request a breath sample while the vehicle is running and warming up. And guess what? You will be in the vehicle to give it one. That's a violation. If you have problems providing a breath sample and the device times out, do not leave your car. Wait until you're able to blow again and then provide a valid breath sample. If you abandon the vehicle, many people, like a probation officer or a judge, will think that you caused the violation. And finally, and oh so importantly, do not remove the ignition interlock device until the DOL says you're okay to do so. The DOL requires a certificate of compliance from your ignition interlock device provider. This states that the final 6 months of required installation has been without user error. You cannot remove the ignition interlock device until the DOL has received and accepted this document. If you remove the ignition interlock device early, you'll have to reinstall it and keep it in your vehicle for another 6 months. All right, and finally, one of the reasons I have a problem with this device is because the technology is archaic. It's very old. You don't know who's used it before you. It's not a new product. You're getting a product that might have been used for many years. It's not a product out of the box. You're leasing it. So you do not know the history of this older device. And to give you an example, this is a beautiful old camera. I think it's from the 70s. It's a film camera. And the pictures it produces, oh my word, they're terrible. On the other hand, we have, an iPhone. It's accurate, it's sharp, it's consistent, and it's reliable. This is not your ignition interlock device. This is your ignition interlock device. The certificate of compliance is the document submitted by your ignition interlock device vendor to the Department of Licensing at the end of your ignition interlock device requirement period. When you're finished with your requirement period, contact your ignition interlock device vendor, the installer, to request the certificate of compliance. They'll submit the certificate of compliance if you have not violated any of the required conditions in the last 180 days. These conditions include attempting to start the vehicle with a breath alcohol content of 0.04 or more, failed to take or pass any required retest, failed to schedule maintenance for your ignition interlock device, such as repairs, calibration, monitoring, inspection, or replacing the device. If you violate any of these conditions, you'll need to restart your certificate of compliance time period, which is for another 6 months. And another word of advice, do not remove the ignition interlock device until the Department of Licensing confirms they have this certificate on file. SR22 insurance is a certificate that proves that you, the driver, carries the required minimum liability coverage. If you lose your license, you will be required to have SR22 insurance for a period of 3 years. If you operate an employer-owned vehicle during work hours, you can submit an employer declaration that will allow you to drive the company vehicle without the ignition interlock device. Now, of course, there are many rules, including that you can only use it for work and you're not permitted to drive the vehicle, the company vehicle, to and from work. And you must carry a copy of this waiver with you whenever you drive the company vehicle. If you're required to have an ignition interlock device, but you're unable to use it because of medical issues, such as not being able to provide enough air for the device, you may be eligible for an ignition interlock device medical exemption. However, you won't be able to drive during this designated time at all. But you do get credit for the time towards the ignition interlock device required time period. And when the time period is over, you will then be able to drive. It's a little bit confusing, so before you go through that process, I highly advise you talk it through with your lawyer. A DUI has severe consequences for a commercial driver's license or CDL holder, even if the offense occurs on a personal vehicle. A first DUI conviction typically results in a 1-year CDL suspension or 3 years if you're transporting hazardous materials. A second offense often leads to a lifetime disqualification. CDL holders also face higher insurance rates, job loss, and difficulty finding new employment since most trucking companies have zero tolerance policies.